charges pending this afternoon. The most serious of those is a murder charge. If you're convicted of that offense, it carries a prison sentence of 15 years to life in prison and a maximum possible fine of $15,000. You have a felony 3 charge of tampering with evidence. That one, if you are convicted, could add up to another 5 years in prison and a fine of up to another $10,000. Finally, you have a charge of abuse of a corpse. That's a 2nd-degree misdemeanor. That one could add up to another 90 days in jail and a $750 fine if you are convicted. Your case is going to be set for a preliminary hearing next Monday afternoon, March 8th at 1:30. You have the right to an attorney. If you cannot afford an attorney and if you qualify financially at your request, the court will appoint one for you and you would talk to that lawyer today. Would you like court-appointed counsel, ma'am?
I don't understand.
You want to talk to a lawyer?
Where's Officer Hoover?
Well, he's not in here right now. What about
Well, I have a learning disability, so I'm not understanding what you're saying.
Court's going to go ahead and appoint counsel Chris Atkins on this case. Can you read the statement, please?
Yes, statement is from Detective Hoover. On February 28, 2021, was assigned a case of a missing 6-year-old child from 507 Crawford Street. As a result of the investigation, was able to speak with the defendant, being the mother of the child. She was read her Miranda warnings and agreed to speak with the detective. The defendant admitted to taking her child to Rush Run Park in Preble County, where she placed him outside of her vehicle. The defendant stated that she was going to leave the child at the park. She told detectives after placing the child outside her vehicle, he attempted to get back into the vehicle and she drove off at a high rate of speed, dragging the child for a distance. The defendant then left the park and returned approximately 30 to 40 minutes later, finding the child in the middle of the parking lot with a head injury. The defendant advised the child was deceased. The defendant stated that she picked the child up, put him back in the vehicle and drove back to 507 Crawford Street, where she took the child into the house and placed him in an upstairs bedroom. The following day, she drove to the Ohio River and disposed of the child's body into the river.
You live at 507 Crawford Street. How long have you lived there, ma'am?
I just moved there the first.
Where'd you move there from?
Dayton,
Where would you live in Dayton?
at a hotel,
And how long had you been living at the hotel?
3 or 4 months.
All right. Where are you from?
Cincinnati.
All right. On the murder charge, court's going to set bond at $1 million, cash surety of property. OR's on the other 2 charges. Ms. Gosney, your case will be back in here next Monday afternoon. You'll be speaking to an attorney this afternoon who can answer some of the questions that you're considering. You understand that, ma'am? All right, that'll be it.
Scratch this one. John, may we approach?
Yeah.
James Hamilton, CRA 2100494, charged with tampering with evidence and abuse of authority.
Mr. Hamilton, you have 2 charges pending this afternoon. You have tampering with evidence, which is a felony of the 3rd degree. If you're convicted of that offense, you could be sentenced up to 5 years in prison and fined up to $10,000. You also have a 2nd-degree misdemeanor charge of abuse of a corpse. That one could add up to another 90 days in jail and a $750 fine if you're convicted. Mr. Hamilton, your case is going to be set for a preliminary hearing next Monday afternoon, March 8th at 1:30. You have the right to an attorney if you cannot afford an attorney and if you qualify financially. If you ask for one, the court will appoint one for you and you would talk to that lawyer this afternoon. Would you like to speak to an attorney, sir?
Yes, sir, I would.
Court will appoint Matt Dixon. Can you read the statement, please?
Statement is from Detective Hoover. On February 28, 2021, he was assigned to investigate a 6-year-old child that had been reported missing. As a result of the investigation, found that the defendant lives at 507 Crawford Street with the child that had been reported missing. Defendant was read his Miranda warnings and agreed to speak with a detective. Defendant admitted to keeping the deceased body of the child in his house at 507 Crawford Street and then disposing of the child's body in the Ohio River.
And sir, you've lived at that Crawford Street address, what, about a month?
Yes, sir.
And according to your co-defendant, you were living at a motel in Dayton before that?
Yes, sir.
And how long were you living there?
About 4 or 5 months, maybe 6.
All right. On the felony charge, court's going to set bond at $100,000 cash surety of property, $5,000 cash surety of property on the use of the court. All right, Mr. Hamilton, you'll be filling out this financial affidavit, and you'll speak to your attorney this afternoon. You'll be back here in this court next Monday afternoon at 1:30, all right? That'll be it.
Just put it in.
All rise. This Court of Common Pleas, Butler County, Ohio is now in session. The Honorable Noah E. Powers is second presiding. You may be seated.
On the record, counsel.
On the record.
Your Honor.
Morning, Mr. Moser. Good afternoon, Mr. Moser. Go
State
ahead.
of Ohio versus Brittany Gosney, case number CR 21030273. And State of Ohio versus James Hamilton, case number CR 21030274.
We're going to arraign these separately.
Okay, well, we will start then with State of Ohio versus Brittany Gosney. Defendant is present in the courtroom along with her attorney David Washington, Kelly Hiley, and Michael Moser on behalf of the state.
Very well, thank you. And Mr. Washington's here representing Ms. Gosney.
I am, Judge.
And how do you wish to proceed with respect to this arraignment, Mr. Washington?
Your Honor, at this time, we're going to enter a plea of not guilty. We're going to waive reading, waive the 24-hour period, and any defect with regard to service. She has received a copy of the indictment greater than 24 hours prior to this hearing. She's 29 years old, Judge. We're going to enter a plea of not guilty to all charges at this time.
Straight not guilty, please.
Straight not guilty plea at this time, Judge. I did have an initial meeting with Ms. Gosney yesterday. I'm going to meet with her again probably tomorrow. There are some issues that that may develop, which may cause me to request leave and perhaps file another plea on her behalf. But at this time, just based upon my limited conversations with her, at this time we're in a straight not guilty plea. Also based upon that, Judge, at this time we're not going to execute a general time waiver. However, that doesn't preclude us from doing that in the future.
Do you want to grow your YouTube channel? Do you want to earn more views, more subscribers, more watch time, and
When was the defendant arrested?
March 1st, Your Honor. Actually, it might have been February 28th, the day before, officially.
Based on that, when do we have to try this case by? Speedy trial date?
I'm thinking right around May 28th.
Your Honor, if it gives the court any, I would ask the court to consider just having us come back in a couple of weeks. I don't know, I don't think speed trial is going to be an issue in this case.
Well, Your Honor, we just want to avoid an issue on that, so we'd appreciate it if you go ahead and set a trial date today, and that we won't have any problems with that down the road, and we won't be second guessing the date.
What's the anticipated time for trial?
The time that it would take.
Yes.
We're looking at, I would say, a week-long jury trial that's under normal circumstances. With COVID jury selection, it may take a little over a week.
Does everybody look on Monday, May the 20th? Well, let's see. 23rd. May the 24th,
That's fine.
set this matter for trial then on Monday, May the 24th, 2021 at 8:30 a.m. Would you like to have a final, or a pretrial between these times?
Judge, I think it may be beneficial if we come back just in a couple of weeks, just to, right now, I think that there's still a lot of evidence gathering going on. Also, I've had one meeting with my client to try to get some information together. Also, with regard to co-defendant, I know that there have been some statements. I haven't read or received any of them, obviously, so I'm not sure if there's going to be a issue regarding trying, I don't think that these two individuals can be tried together.
I'm setting the trial date for her.
Okay.
About March 22nd, 8:30. That's a Monday.
Okay, that's what I was going to ask, Judge. You said March 22nd, Judge?
Yes, it'll be 2 weeks from today,
At what time?
8:30 a.m.
That'd be perfect, Judge. Thank you.
That's fine, Your Honor.
Anything else we need to discuss at this time?
There's no bond at this point in time.
I was under the impression the bond had been set at $2 million. All
It was set at the lower court, but that case would be dismissed.
right, very well.
Judge, with regard to bond, obviously, this is, the allegations are very serious. We recognize that. She's 29 years old. She has no prior contact, no prior record. We ask the court to set a bond that's reasonable.
Prosecution wishes to be heard.
We thought the bond that's set earlier, Your Honor, was reasonable, or it would have been set at $2 million. We're satisfied with that. Continuing.
Very well, we'll set bond at $2 million, cash or surety. We'll also order that if the defendant is released, that she report to pretrial services on a weekly basis with drug tests, and we'll also order the GPS unit replaced on her.
Thank you, Judge.
Thank you, Your Honor.
Anything else with respect to Ms. Gosney?
No, Your Honor.
Well, she got a sheet for you. See it right there. Here's the sheet for you.
Next case, State of Ohio versus James Hamilton, case number CR 21-030274, Jeremy Evans on behalf of the defendant, Charlie Miley and Vice Moser on behalf of the state. Set today for arraignment.
Here we go. Do you wish to proceed here with respect to arraignment, Mr. Evans?
Good morning, Your Honor. Jeremy Evans on behalf of James Hamilton, who appears in person. Mr. Hamilton is 42 years old. He's able to read, write, and understand the English language, having earned his GED. He is a U.S. citizen born in Hamilton County, Ohio. He has been served with a copy of his indictment within the last few hours. We would waive the 24-hour waiting period, waive the reading of the indictment in open court, and enter a not guilty plea for the second half of the indictment, counts 17 through 31. We would ask to be heard on the issue of bond and her plea of, indicated in her plea of not guilty. I would indicate also to the court that if the court is interested in tracking these cases together, I'm available for a plea or trial in 2 weeks. I did file a notice of appearance of counsel request for discovery and bill of particulars today, Your Honor. I just met him today, so there's a lot of information that needs to be gathered.
And has he waived the speedy trial?
No, Your Honor.
Right. Was he arrested on the same date?
Yes, he was.
90 days is calculated at May 28th. If the 28th of February was the date of arrest, Your Honor.
He waived defects in service. I may have missed that.
So waive, Your Honor.
You wish to be heard on bond?
Yes, Your Honor.
Proceed.
Thank you. Understanding that these co-defendants are charged for a course of conduct alleged to have been enacted together, I would indicate to the court under the criminal rules, he is not charged with murder or felony of the first degree, although his charges are serious. Would indicate to the court that he has been a resident of Butler County for the last 9 years or so. He indicates to me that although he does have some prior felony history, it has been since about 2007 that he's had any contact with the court on a felony level. He's not on any probation, parole, post-release control, reporting to any other courts at this time. He is an electrician, has been employed through the same company for about 7 years. Would indicate to the court that he has no source of income, obviously, while he's incarcerated. And as the rules anticipate the court considering a bond, that would be something that he would potentially be able to meet on anything other than a murder or a felony of the first degree. We would ask the court to consider setting bond significantly lower than the co-defendant, given the charges in this matter.
State wish to be heard?
Yes, Your Honor. The charge against this defendant, while not murder, certainly based upon the evidence that will be presented, will show acting with the other defendant in this case in concert with certain issues. Defendant is charged with second-degree kidnapping, and that is a very serious offense. Multiple counts, actually, along with others. Defendant does have a prior criminal record, burglary, 1999. Later on, weapons under disability. I would represent this defendant, represents a threat, and as a result, we ask for a substantial bond. His co-defendant has a $2 million bond while he's not charged with murder. The allegations of his participation in that egregious offense certainly would justify making sure that this defendant is available for trial. We're asking for $1 million bond with respect to this defendant.
Anything else you'd like to say with respect to bond, Mr. Evans?
I've made my argument to the court. Thank you, Your Honor.
Right, we'll set this matter for trial on May 24th, 2021 at 8:30 a.m. We'll deal with any issues regarding whether they should be tried together at a later date. We'll set up pretrial for March 22nd, 2021 at 8:30 a.m. We'll set bond in this matter at $750,000. We'll order that the defendant be placed under if he's released, be placed under the custody of pretrial services with an order to report weekly. He'll be placed on a GPS unit with random drug screens. He's to have no contact with the alleged victims, and he assumes the obligation of determining the date, time, and place of all subsequent appearances, and to maintain contact with Mr. Evans. Respond immediately to all calls from Mr. Evans and not to change his address or telephone numbers without advising Mr. Evans. Anything else?
Not by the state, Your Honor, thank you.
Very well. That'll be the order. We'll see you all back here on March 22nd.
Thank you, Your Honor. No, we'd have to post 10% to the bonds now. The difference is it's still 10%.
Stand adjourned.
The direct bonds recorded. Otherwise? And the bonds is going to keep 10%, so it's 75,000. Okay. December, this is for you. Coming back on March 22nd for your next hearing. That's 2 weeks from today. Your trial is currently scheduled for May 24th. That doesn't mean that has to be the day it's going to happen. The judge wanted to go ahead and schedule one just in case to make sure your rights are not violated. Okay?
Yes, sir.
Okay. I'll be over to see you in about a week.
All right, thank you, sir. Yes, sir.